Good morning, everyone, and welcome. Before I begin, I'd like to remind the audience that French interpretation is available for this webinar. And so to enable French interpretation, you can click the button in the bottom right corner. You'll see a little globe that indicates interpretation. You can also turn on live transcription or closed captions, which is also located on the bottom corner of your screen. Just to note that this live transcription is automated, which may be reflected in the accuracy of the closed captions. My name is Ariana Magliocco, and I am the Communications and Public Education Coordinator at the Canadian Feminist Alliance for International Action, or FAFIA. Founded after the Fourth World Conference on Women in Beijing in 1995, FAFIA's work focuses on defending women's human rights and advancing women's equality, especially through engaging with UN treaty bodies and advocating for the implementation of Canada's international human rights commitments. FAFIA is located in Ottawa, which is on the traditional unceded territories of the Algonquin Anishinaabe Nation. We recognize both our responsibility and obligation to the peoples and land of the Algonquin Anishinaabe Nation, on whose traditional territory we work, learn, and live. Today, we are joined by four prolific women to discuss the forced assimilation of First Nations women under the Indian Act. We are joined by Mary Eberts, who is a constitutional lawyer and human rights advocate, Pam Palmater, who is a Mi'kmaq lawyer, professor, and chair in Indigenous governance at the Toronto Metropolitan University, Sharon McIvor, who is a lawyer and professor of Indigenous studies at the Nicola Valley Institute of Technology and plaintiff in McIvor versus Canada, and Joyce Green, who is the professor at the Department of Politics and International Studies at the University of Regina. My colleague Shivangi will be listing a more fulsome biographies for all of our panelists today, who we are so appreciative of taking time with us today. Our discussion will be moderated by longtime advocate and FAFIA Human Rights Committee Chair, Shelagh. And before I hand it off to her, I would like to quickly thank WAGE for the funding which has made this event possible. I would also again like to remind anyone who's just joined that French interpretation and live transcriptions or closed captions is available and can be enabled by clicking the relevant buttons in the bottom corner of your screens. Throughout the webinar, you can also ask questions to our panelists. And if you wish to ask questions, please use the Q&A function as opposed to the chat function, as that's where we'll be filtering through questions to ask the panelists later on during the webinar. The webinar will also be recorded and uploaded to our YouTube channel shortly after this live broadcast. And so thank you so much for attending, and I'll hand it off to Shelagh.
Thank you very much, Ariana, and thank you to everyone for being here. We're very excited to have this webinar this morning. For many years now, FAFIA has been working alongside First Nations women and their organizations and allies to put an end to sex-based discrimination in the Indian Act. Today, we're proud to have this panel of amazing experts, scholars, and leaders to talk about the history and the current state of Indian Act sex discrimination. I want to make one note to start with. Today's speakers will often use the term Indian, though preferred terms now are First Nations or Indigenous. But Indian is a legal term used in the Indian Act to refer to those who have status or are entitled to status, and that's why speakers will use it today. Since the 1970s, Canada has ratified a number of key international human rights treaties. Compliance with the rights set out in these treaties is an obligation that Canada has committed itself to, and that it urges on other nations. For some decades now, every treaty body that reviews Canada's compliance has urged Canada to remove the sex discrimination from the Indian Act. But in 2022, it still has not been completely removed, and the harms that it has done have not been repaired or compensated for. The discrimination in the Indian Act has been found by courts and treaty bodies to violate the rights of First Nations women to equality and to enjoyment of their culture. Today, it is also important to recognize the sex discrimination as an instrument of forced assimilation. Sex discrimination in Canada's Indian Act is a key component of the genocide identified by the National Inquiry on Missing and Murdered Indigenous Women and Girls, and it is a foundational piece of Canada's history. We know about Canada's policy of getting the Indian out of the child through residential schools, day schools, and the 60s scoop. Less understood is that Indian Act sex discrimination has been one of Canada's primary tools for getting the Indian out of Canada. Through a discriminatory definition of who is an Indian, the law has stripped First Nations of thousands of women and their descendants, shrinking the pool of Indians who are recognized by the Government of Canada as having inherent Aboriginal treaty and land rights. The sex discrimination has worked effectively to damage First Nations women and First Nations. Over 50 years of advocacy and legal challenges, First Nations women have made gains because of their amazing resilience and persistence. In 2017, First Nations women won a big victory with the help of the Senate Committee on Aboriginal Peoples. They secured an amendment to the Indian Act that eliminated the core of the pre-1985 sex discrimination. This amendment came into force 3 years ago in August 2019, and estimates are that somewhere between 270,000 and 450,000 women and their descendants are newly entitled to status because of it. These numbers demonstrate just how effective a tool of forced assimilation, sex discrimination has been, since there are only slightly more than 1 million status Indians in Canada now. That's the good news, that amendment was won. The bad news is that 3 years after that amendment, most of these women and their descendants still do not have status. They must be registered in order to benefit from their new entitlement and to confer status and its incidence on their children. Most of them are still not registered. Canada says repeatedly that it wishes to get out of the business of Indian registration. However, it's clear that if the government gets out of the business of Indian registration before it restores the women and their descendants to their rightful status and membership in their communities, it will cement in place the discrimination for all time. This is not the path to reconciliation. We are working to move us forward on that path to reconciliation, and we know that truth is the first step. Today, we hope to answer these questions. How does sex discrimination in the Indian Act work? What have First Nations women done to challenge the sex discrimination? Where are we now? Why does it matter to recognize the sex discrimination as a tool of forced assimilation? Why does Indian status matter? Why not get rid of the Indian Act right now? Why is the Government of Canada so slow and reluctant to remove the sex discrimination? And finally, what can we do? Now I want to turn this over to our first speaker, Dr. Pamela Palmater. Pamela.
Thanks, Sheila. And I think we forgot to introduce Sheila because she's a kick-ass warrior for human rights and has been forever. And she is one of our staunchest allies in human rights. So thank you, Sheila, for all the work that you do to support us, and FAFIA too. So I'm from Eberts First Nation, a Mi'kmaq territory, but today I'm coming to you from Mississaugas of Scugog territory. And I don't speak for the Mississaugas, but we often share the same views. And I think it's important to note that while tomorrow is Veterans Day, a Remembrance Day, November the 8th was National Indigenous Veterans Day. And so it's important to recognize what's happening around us. It's such an honor to be on this panel because I just look up to these women so much. And so I think we're, just going to dive right into it. The big question I often get asked is why? Why is this happening? It simply doesn't make sense in a context of a prime minister or a government that says there's no relationship more important than one with Indigenous peoples. It's about a nation-to-nation relationship. It's about respect for rights, and not just this government, but every government. So the question is why? That just seems very irreconcilable. And how could Canada say that Canada was created out of these great relationships between Indians or First Nations and settler governments? Some have described it as an inevitable clash of cultures. That's why that was natural to happen because of different cultures. Or maybe some people just didn't like us. Or conversely, what some ministers have said in the past is, we had good intentions. We just didn't expect that these things would happen. Kind of like an oops. But despite what the history books may say or what politicians say, this is not about a cultural clash. That's why trying to resolve these problems with cultural awareness training can't ever address the issue, because the issue is genocide, racism, misogyny, and violence for a very specific purpose. And it had nothing to do with whether or not they liked our culture. So in order to understand how that history has continued into the present, you have to understand that our entire relationship between First Nations in Canada and even the provinces has been based on this draconian, outdated Indian policy. And Indian policy in this country has always only ever had two objectives: to get Indigenous lands and resources, and I would argue trade networks, and two, to reduce financial obligations assumed through things like treaties and other agreements or the creation of reserves. Again, for these two objectives, they only ever had two methods. That's it. One was elimination, just like physically eliminate Indians. And two was forced assimilation. Elimination, we don't talk about much, but it looked like the scalping bounties placed on the heads of my nation, the Mi'kmaq, after we signed peace treaties. Forced sterilizations on Indigenous women and girls, some girls as young as 10 and 11 years old. Starvation policies meant to wipe out a people. And of course, the deaths of children. And assimilation looked like you had to give up your Indian status to go to work. You had to give up your Indian status to get an education. The forced assimilation of Indians via the Indian Act, the whole reason why we're talking about this today. Because if we follow through with the formula in the Indian Act, it's a disappearing Indian formula, you can calculate a legislative extinction date for every First Nation in this country. And that is something that we don't talk about. So you can't, on the one hand, advocate for our political, legal, cultural, social disappearance, while at the same time say you respect our rights and we're working on a nation-to-nation basis. We know that forced assimilation, not just through the Indian Act, but through residential schools, Indian residential schools, Indian day schools, forced adoptions, you name it. Canada has continued on its Indian policy mission to eliminate or forcibly assimilate us. So this was never about culture. It was always about getting rid of the Indian problem. And that's not my words. That's the federal government's words. It was always about the final solution to the Indian problem. And we all know where we heard that before. Again, those are the government words. And of course, the targeting of Indian women and children to sever their connections wholly with their nations. That was literally in black and white in government documents. Why? Why? Well, here's the answer to that question. Indians stood in the way of absolute colonial power, control, and wealth on this territory. So Indian policy meant eliminating Indians by any means necessary. And we know today that those means collectively add up to be genocide. Now, keep in mind, long before there was a convention on genocide, there was an international recognition of these kinds of actions as being genocide. But along comes the UN Convention on the Prevention and Punishment of the Crime of Genocide. And we now know, and it's undebatable, that Canada engaged in both historic and ongoing genocide. The historic stuff, people can maybe sort of get their minds around because they feel some distance to history, but it's the ongoing genocide, like the disappearing Indian formula in the Indian Act, that has people really confused about what politicians are saying versus what they're doing and the arguments they make in court. So we know, though, from the National Inquiry into Murdered and Missing Indigenous Women and Girls, that Canada is guilty of genocide. And here's the hard part about that conclusion. You cannot be found guilty of genocide without intention. So there's no accidental genocide. You must intend to destroy the group in whole or in part. That's what the law says. So this is about intentions. And when you think about that, not just historically, but ongoing genocide, they intend to get rid of us. So what happened after the National Inquiry? Prime Minister accepted the finding of genocide and then went on about his day to his next meeting, as if you could just say, I accept the finding of genocide. Now let me go on to my meeting and not take any action. After that, we got caught up in the political debate about genocide, that, only the Holocaust was genocide. And don't get me wrong, the Holocaust is one of the worst genocides, but you can't compare genocides. They happen in different places, in different times, with different political situations. And we know by the definition of genocide that you need the intention to destroy a specific group, Indians, by destroying them in whole or in part. So no, you don't have to wipe out all Indians in order for it to be genocide. It doesn't require killing people, but it can include it. So for Canada to be guilty of genocide, it had to have done one of 5 things: kill Native people, which they did, cause severe physical and mental harm to try to destroy the group, and I think we can argue that Canada did, create the conditions of life, like severe impoverished conditions or lack of housing, lack of water, that would help bring about the destruction of that group, the forced sterilizations or preventions of births in that specific group, and of course, the forced transfer of children in mass numbers from Native people to the non-Native community. Canada needed to only be guilty of one of those things. It's guilty of all 5. And it doesn't matter whether you characterize it as them doing specific acts of genocide, or the conspiracy to commit genocide, the incitement to commit genocide, the attempt, or complicity. So that literally covers all of Canada's actions. We know historically, scalping bounties, forced sterilizations, kicking women out of their communities out of the Indian Act. But that still continues today. There's still forced sterilizations, there's still child theft, and there's still the elimination of First Nations women and our descendants from the Indian Act. And by not being registered, that has very significant consequences for whether or not we can belong to our First Nation and also our larger nation. So this targeting continues today, and it's one of the most effective forms of forced assimilation, because we're not just talking about 10,000 First Nation women, and that would be bad. We are talking about hundreds of thousands of First Nations women and their descendants that have been wrongly excluded from recognition of who they are as First Nations and belonging to their communities, the denial of their treaty rights, and all of the subsequent violence that followed. Because we know from the National Inquiry, one of the root causes of genocide against Indigenous women and girls is ongoing and historic sex discrimination in the Indian Act, treating us as though we're not equal. We shouldn't have the benefit of protections of human rights laws or any other protection. This has had a significant impact on all of us. So think of the hundreds of thousands of people that are excluded, the fact that it makes our First Nations communities even smaller and easier to control by the federal government. The same thing with our nations, shrinking and shrinking and shrinking our nations. And people might say, oh, just get rid of the Indian Act, or it doesn't matter if there's no legal recognition. And we wish that was the case. But as the law stands right now, if there are no more legally recognized Indians under the Indian Act, and like I said, there's a legislative extinction date for every First Nation in this country, what does that mean for the Indian band under the Indian Act? Well, it means they don't exist anymore. What's the legal ramifications of not having a legally recognized band? Well, all of your land, all of your resources, all of your treaty rights, all of your Indian monies under the Indian Act they all escheat to the crown. And escheat is just a fancy word for saying it reverts or goes back to the crown. In most cases, the provincial crown. There may be some cases where it's a federal crown. But do you see what I mean? There is a vested economic and political and power interest to make sure that they get rid of the Indian problem. Don't listen to anything they say or any denials. You need only step into any courtroom in this country or at the United Nations to hear the Justice Canada lawyers and Indian Affairs officials vehemently defend their right to maintain this disappearing Indian formula in the Indian Act and maintain all of the ways in which First Nations women and their descendants are specifically targeted for exclusion. Here we are today. There is still no accountability. And to add and make it even worse for all of these human rights violations, the genocide, the sex discrimination, and the failure to remedy it today, to actually register these people and make sure they're included, is the fact that in all of those legislations, all of the amendments to the Indian Act registration process is a non-liability clause that says, listen, we were just doing this in good faith, so we can't be held liable for enforcing genocide, which effectively means they are unjustly enriching themselves or profiting from genocide by all the money they allege to save by not having to recognize the rights of First Nations women and children. That's wrong, it's unconscionable, it's immoral, it's illegal, and it is about time that we address it, which is why we are having this webinar. It's far more urgent than you think. It even impacts the kids in that human rights case on foster care, or First Nations who are negotiating self-government agreements or land agreements, any of those things. We're being excluded from that, and it's high time that it stops. And the best way to stop it is for you to learn more so you can push the government to end this.
Thank you, Pam, for those amazingly wonderful and sharp and hard opening remarks. I'm going to turn now to Mary to talk about the Indian Act, sex discrimination, and how it works. You're on mute, Mary.
I was on mute so that nobody would hear my Great Dane barking. The Indian Act was passed very soon after Confederation in 1876. It has survived since then as an instrument for the control of those subject to it, all of whom the government classifies as Indians, even though they are members of many different Indigenous nations. Control and eventually disappearance. Before contact, Indigenous nations inhabited the landmass that is now called Canada. Each had a territory, a mode of organization, a language, religion, a method of determining membership and ordering family life. The colonizers did not recognize any of these. Moreover, land purchases or treaties constituted the settler government or its agents owners of land occupied and cared for by Indigenous peoples. Where there were treaties, these were administered under the Indian Act. The Act's dominance was so complete that scholar and activist Harold Cardinal stated that Indian leadership feared that treaty rights would be lost if the Indian Act were to be declared invalid because of discrimination against women. He gave this as the reason why the National Indian Brotherhood appeared in the Supreme Court of Canada to oppose the efforts of Jeanette Laval and Irene Bedard to challenge sex discrimination. The Indian Act was then one of the instruments, along with treaties and land purchases, implementing Canada's plan to claim land and the efforts to extinguish Indigenous culture, religion, and language, which then Chief Justice Magliocco characterized as cultural genocide. The Indian Act did more, and this is where we get to actual genocide, the one that Patricia was talking about. Canada, as a settler state, aspired to legal jurisdiction over all land formerly occupied and tended by Indigenous peoples. To accomplish that on a long-term basis, it was necessary to make the Indigenous occupiers disappear. The maxim terra nullius guided European actions in the New World at that time, the land of no one. And the Indigenous peoples of Canada at contact had to be rendered null as part of the colonial project. If they could not be eliminated through death, usually from disease or starvation or any of the other methods Patricia mentioned, then they would be transformed into people who no longer had to be recognized. The scheme by which Canada sought this erasure is contained in the Indian Act. The category of Indian is created by statute, and conditions set out which entitle a person to be registered as an Indian. The government set up the Indian registry system for administering these provisions. No matter what the person's position in her or his original nation, if they were not registered as Indians under the Indian Act, they were not recognized by Canada as having any interest under the Indian Act, and importantly, under the treaties which had been signed with nations. The overall intent and methodology of the Indian Act was to ensure that over time, all Indians would disappear. Current research is affirming that this is indeed happening, with many bands, First Nations, having only 1 to 4 generations of people still remaining before that happens to them. In early days, the government referred to this process of assimilation as the gradual civilization of Indigenous peoples, simply a grand and racist name for assimilation. The first attempt by Canada to engineer the assimilation of, quote, Indians was enfranchisement, introduced before Confederation in 1857. In this scheme, men with certain qualifications or characteristics were allowed to shed Indian status and acquire land, which ultimately would become the property of their children. Eventually, they would be able to vote. When a man enfranchised, his wife and children were also enfranchised. Men were not attracted to the enfranchisement option. Comparatively few took it up in the long period before its abolition in 1985. Even though Canada used compulsory enfranchisement in certain periods, the total of enfranchised men was very small overall. Canada thus relied on depriving Indian women of status in order to accomplish the assimilation it desired. This was a measure consistent with the masculine privilege of the mid-19th century when it was put into place, but it has lasted and lasted through to today. Under the Indian Act of those days, only a male with status could give status to a couple's children. He could also give status to his wife if she did not have it. If a woman with status married a non-status male, even if he were fully Indigenous by descent, she would lose her status under the Indian Act, and the couple could not transfer status to their children. In this fashion, women and their children were assimilated into Canadian society. That women and children without status could not come into her old reserve to visit family and friends. They were essentially cut off from their culture, their family, and their society. The only opportunity for a woman to confer status under the old system arose in the case of a single woman having a child outside marriage. Unless someone could prove that her child had been fathered by a non-status male, the child would derive status from the mother. This system prevailed until 1985. Bill C-31, passed that year, required that a person have 2 status parents in order to receive status. A person with 1 status parent would receive status for his or her own lifetime, but could not pass on status to any children unless the other parent of those children was also status. The legislators could have chosen to equalize the position of men and women simply by providing that status women as well as men could pass on status to their children. However, they chose to impose a rule on both parents that was harsher than the one formerly applicable to men. This, in the equality litigation business, is called equality with a vengeance. In doing so, they wiped out the previous ability of single women to pass on status to their children if no one could prove the father was non-status. The new rules made it harder for women to confer status than it was for men. It is easier to establish who is the mother of a child than who is the father, and thus easier for a father to withhold his consent to being registered as a parent. He thus maintains control over the success of the registration process. Not quite as much control as he had under the old scheme, but a considerable amount of control nonetheless. The 1985 amendments, importantly, did nothing to place descent through the mother, through the female line, on the same legal footing as descent through the male line. Sharon McIvor's subsequent legal challenge succeeded at the trial court in BC in reversing this discrimination and establishing the equality of descent through the female line. It was a groundbreaking case. On appeal, however, the BC Court of Appeal narrowed her victory to one technical point, and she has spent the last several years challenging that outcome under international law. Bill C-3 was passed after Sharon's case to address the technical point identified by the Court of Appeal, assuring status to the children of women returned to status by Bill C-31 after marrying out. In the Deschenaux case, Justice Mass of the Quebec Superior Court criticized the federal practice of correcting the Indian Act on a piecemeal basis, responding only to judicial decisions invalidating a particular provision. This piecemeal approach is demonstrated in Deschenaux itself, as well as Gale v. Canada, Helly v. Canada, and Matson v. Canada. This latter was brought under the Canadian Human Rights Act, which, like the Charter, is available to challenge sex discrimination under the Indian Act. These are all cases dealing with inequities left in the Act by the 1985 amending legislation, which purported to be a wonderful breakthrough measure. Following Deschenaux and Gale, Canada passed Bill S-3. Although it was initially intended to address only the legislative flaws invalidated in the Deschenaux and Gale cases, Bill S-3 was transformed by public pressure and the vigorous leadership of Senator Lillian Dick into a bill that was intended to be comprehensive. It addressed inequalities in the legislation and its application back as far as before 1951, and sought to put all Indians in the position of having full status as provided by Section 6(1)A of the Indian Act. In fact, the rallying cry of proponents of the broader act was 6(1)A all the way. So where are we now? Canada once again is tabling a bill to address only two legislative inequalities. These were not addressed by Bill S-3, in spite of its broad scope. One is the entrenchment of the women and children. One is the enfranchisement of the women and children of men who enfranchised. The other is the long-standing provision that when a status woman marries a status man from a band other than her own, she is transferred to her husband's band. Two glaring discriminatory provisions are left untouched. One is Section 6(2) of the Indian Act, which provides that the child of only one status parent gets status only for life and cannot pass it to the next generation unless he or she parents with another status person. Men can refuse to consent to being named as a parent and condemn the child to this 6(2) fate. In cases of rape or incest, naming the father would cause a lifetime of problems for the child as well as its mother. The best remedy for this situation is to establish that either the mother or the father can give status to a child, replacing the two-parent rule with a one-parent rule. The The other issue is the presence in the Indian Act of a ban on reparations for women and children prejudiced by the discrimination in the Indian Act. This ban is egregious in an age when Canada has already granted reparations for so many of the rights violations associated with colonialism: Inuit relocation, the slaughter of Inuit sled dogs, residential school attendance, day school attendance, the 60s scoop, First Nations child welfare inequities, unsafe drinking water, and flooding. Over a century of sex discrimination in the Indian Act has resulted in dislocation, exile from community, family, and culture, poverty, and exposure to violence. It is a gross violation of equality rights under the Charter for there to be no reparations for these harms. Lastly, there is a pressing need for improvement of the registration process. People are not informed of changes in legislation which may benefit them, and so they don't apply for a change in status. Even when they do, processing the applications can take 3 years and more. Elderly people cannot afford this leisurely pace, nor can others tolerate the continued uncertainty and deprivation of benefits inherent in this meandering process. And what this overview of the Indian Act shows us, not only does the policy of assimilation continue, it is constantly being refreshed by the federal government. And there is a strong reluctance on its part to change any part of it until a court says that it must. That in an age of the Charter of Rights and UNDRIP and other international obligations is Canada's shame.
Thank you, Mary, for that description of the incredible complications of the Indian Act, sex discrimination, and what it has done over decades. It is one of the most Byzantine pieces of legislation that I think Canada has, because it has been amended and amended and amended, often making it some things better and other things worse. I'm going to turn now to Sharon McIvor, who has been one of Canada's leading champions of the work to get rid of the sex discrimination in the Indian Act. Sharon, because of her persistence and determination and work, is the grandmother of thousands of Indigenous women, of First Nations women and their descendants. That is, because of her activism and work, thousands have gotten their status who wouldn't have had it otherwise. So Sharon, it's over to you.
Thank you, Shelagh. I just wanted to say that the legislation has been devastating for us as Indigenous women. And at birth, when I was born, the definition of person in the Indian Act was anyone other than an Indian. And the definition of Indian in the Indian Act was a man, his children, and his wife. So when I was born, I was neither a person or a person at law or an Indian in my own right. I was an Indian because of my parentage. So when I started off, I had nothing to be recognized as a woman as far as the Indian Act legislation was concerned. And there was a whole lot more in there, but it's been a long battle. The fact that there were cases that went on, a woman by the name of Mary Two Acts Early was one of the women that was very vocal and worked really hard at trying to get her status reinstated. She did wonderful work and was a model for those of us who followed. And as was stated earlier, Jeanette Corbière-Laval and Yvonne Bedard did a lot of work trying to get it recognized, and the Canadian courts refused to recognize the discrimination. And so they were unsuccessful. Sandra Lovelace, who took her case to the United Nations Human Rights, got a positive decision from the Human Rights Committee at the UN, basically saying that having lost her status and not being able to go home after her marriage broke down was in violation of the UN covenant. And my personal case started in when in 1985, Bill C-31 was enacted by the federal government, and they led everybody to believe that they did it just out of the goodness of their heart. They saw the inequalities and they decided to change it. Well, that's a lie. On April the 17th, 1985, Section 15 of the Canadian Charter of Rights and Freedoms kicked in. That was the equality rights section. They had they were forced to change it because they were in violation of the sex discrimination prohibitions in the Charter of Rights and Freedoms. So they changed it. And not only did they not change it by April the 17th, 1985, the act wasn't declared until June the 28th of 1985. So they were a few months behind trying to catch up and do what they should have done without being forced. They could have done it in 1982 when the Constitution Act was enacted. So when it forced us as Indigenous women to go forward, and I know that what we haven't touched on yet today is the fact that our male counterparts, the Indigenous men or Indian men who didn't lose their status and were in charge of everything, decided that they didn't want the changes. And what they did was when Jeanette Laval and Yvonne Bedard's case came forward, they stood on the other side. They opposed the case, and they stood in line with the government saying, well, we do not want these changes to happen. And I can tell you that throughout the time that I've been able to move forward on some of this, the men have been, for the most part, on the other side. And I've had to deal with them opposing equality as well as the government. So when we moved forward in 1985, when the legislation changed, I applied to get my status, which I did, and my son was not, or my children were not added because of the rule that they were talking about that gave me 6-2 status. So I challenged it, and I went through the regular system. So you appeal back to the registrar to have them have another look and try to get them to change their mind and give me and my kid's status. And that was refused. So it was in July of 1989 that I filed the appeal to the federal court, or actually the county court, to have it reviewed by the courts. And it took from July of 1989 until October of 2006 to get the case into court and have the case considered. And the primary purpose of not being able to get to court was the Department of Justice going in and saying that they weren't ready. And we were finally able to get into court and had a positive decision. But the impact of the legislation affected me and thousands, tens of thousands, perhaps hundreds of thousands women that were thrown out and unable to have any contact with their families. Mary Two Axe Early was very, very vocal in saying that the there was a portion of her reserve, which is Ganawagi outside of Montreal, portion of her reserve where they leased a piece of land to the non-Indigenous people where they could put a cemetery for their dogs. So the non-Indigenous people could buy a plot and put bury their dogs on reserve. And Mary was very vocal in saying, she said that white man's dog can go and be buried on the reserve, but because of the Indian Act legislation, I'm not allowed to be buried on my own reserve. So the battle was long and hard. We talk about Mary Two Acts early, and the various women that were outside, unable to go into their communities. The other thing that was really indicative of what the intention was is when these women married and were thrown out of their communities, they had very little contact with their families. And I was doing research and ran across several cases in BC when I was doing another case where men who were doing traditional fishing were charged. They had their nets taken, their fish taken, and they were charged with providing Indian food fish to a person that was not entitled to it. And these cases were cases where a father, an Indian father doing his traditional fishing, provided the food fish to his daughter who had married out and had lost her status. So it's really indicative that the separation and the removing the women from the community was complete, because she was out in the community. She had no support whatsoever. In many cases, these relationships broke down. And so she was out of the community without any support of the community and had no one else. So when we're looking at the impact of the legislation, on its face, it doesn't say much, but FAFIA, through FAFIA, I and Shelagh Day have done a lot of work in the international forum, and we've had a lot of success. Pam Palmater has also come with us to various venues when we go out to tell either the United Nations or the Inter-American Commission on Human Rights what bad actors Canada is. And so we did get very positive response from the international community. The both the UN committees that we went before and the Inter-American Commission on Human Rights tied the historical Indian Act. Sex discrimination is the root cause of high levels of violence against Indigenous women, and the existing vulnerabilities that make Indigenous women more susceptible to violence, tied directly to the Indian Act. And on the issue of, and that's on the issue of missing and murdered Indigenous women. If you look at their report, they recognize the genocide that's going on. There's a Senate report, and also Claudette Dumont-Smith report. All of those tie directly the issue of missing and murdered Indigenous women and girls directly back to the sex discrimination in the Indian Act. The proposed amendments, I know that again, when Bill S3 was going forward, the Senate was great. We were able to interact with them and explain to them what we needed to get the bulk of it out. And they were very good and very supportive. And not only supportive, they were actually defiant to the House of Commons. And they did say that basically, if you because the amendments were made, went back to the House of Commons. House of Commons just changed it back to what it was. And then they wanted to send it back to the Senate. And the Senate said, no, if you send it back to us, we're just going to change it back. So they got into a bit of a deadlock. But what ended up, albeit a little later than we'd hoped, we did get the bulk of the discrimination out. Although the proposed amendments now, what we were looking for was the total elimination of what was left, the issue of the women not going back, being able to go back to their natal bands. They were born in one band when they married somebody that didn't belong to the band. And that happened because they were in residential schools where they're members of all bands were at the same residential school, and many women married man that they met at the residential school, automatically transferred them out. And when they changed the legislation in 1985, they left them with their bands. There was no mechanism for them to get back to their birth bands. And I've heard lately that, well, not lately, in the last probably 15, 20 years that I've been working on this, is that the same argument that Mary Two Acts Early said. I'm stuck in, she was stuck outside, and if she died, she couldn't get buried on her reserve. These women are stuck with bands that they weren't born into, and a lot of times they're very hostile because the marriage didn't last very long, and they can't be buried on their own reserve because they're not members of the band. So the proposed amendments are okay, but the 6-2 cutoff of status leaves us in quite a dilemma, because in 3 generations, actually in my great grandchildren, I've got 3 great, well, actually 2 and almost a 3rd great grandchild. She's due in about a week and a half. They're not eligible for status. So I've got my children, my grandchildren, but my great grandchildren are not eligible for status. And so the other thing that is really distressing is that these are birthrights we have. You know, we've got legislation saying, you know, Section 35, that all of our existing Aboriginal and treaty rights are confirmed and recognized. But we have birthrights, and then we have legislation that also discriminate or prohibits discrimination against us, and we're stuck in a cycle of consultation. And over the years, I've been very adamant that those rights I have, my Indigenous rights and my human rights, you shouldn't be able to consult with somebody else to ask if it's okay if they recognize that I have those rights. And we're still in that dilemma. We were in that dilemma pre 1985 and C31. We're in that dilemma in 1989 to 2006 when the McIvor case was going forward. And now we're back in it again. They want to consult with the Indigenous groups and others to find out if it's okay if they recognize our Indigenous and human rights. And so it's something that most law says you can't do that. You know, you either recognize, if it's there, you have to recognize it, and they're not recognizing it. So the consultation is a process that they use. So there were a lot of us that will die out during that period of time, that before our rights are recognized, we're dead. It may pass on to our children or not, depending on how far the children are, or the grandchildren, the great grandchildren are. And so the international law, there's, you know, the international UN human rights law, the laws on just race, the laws on discrimination against women, and there's UNDRIP and others that all recognize that Canada is not complying. And we've been there. I mean, Pam and I and Sheila have been there, and we've heard them and we've seen them write letters to Canada and others to tell them to stop discriminating and clean everything up and do some reparation. And Canada is just sitting back and letting us die off in hopes that we'll go away. But I don't think that's going to happen. Thank you.
Thank you, Sharon. Now I'm going to turn to Joyce for final remarks, and then I hope we'll have some time for questions. Joyce.
Good day, everyone. Joyce Green. I'm happy to see you all. Thank you, FAFIA, for the invitation to speak here and in the presence of such giants for Indigenous women's political rights as I speak with today. I am here where two creeks meet, known as Cranbrook, in Tunuka territory. My Tunuka ancestral community is Yakadak Nukliet, or Tobacco Plains. But I am also of English descent and of Métis descent. And parenthetically, let me note that the Canadian government unleashed armies on the Métis and dispossessed them of every bit of land they ever had. And so I cannot also forget the Métis Nation. I am learning something of my language, my Tunuka language, in my 60s. I was not raised with my language because my grandmother and her generation were taught to turn their backs on their Indigenous identities, communities, language, and families. My grandmother may have learned this at residential school, or maybe in the racist settler community, or perhaps in her family. I suggest they learned to hate themselves. The result was a crippling, sometimes fatal dysfunction bequeathed to us all, suffering as we are from the loss of family relationships, culture, community, and self-esteem. Colonialism maims and it kills. So many of us have not thrived in my family. I am the only survivor of my siblings, and I am the oldest. Now I struggle to learn the sounds, the words, the conceptual framework of Tunuka. It is salve for my soul. My family did not lose status through marriage. We were never registered. And please think about the assumptions in that registration thing. I am told my great-grandfather forbade the registration of his 8 children because he feared them being taken to residential school. I do not know if this is true, and there is no way to fact check with dead men. However, it seems that 2 of his children, my great aunt and my grandmother, were taken to St. Eugene Residential School after his death. In the name of my grandmother, Bessie, and for all my family, I greet you in Tunuka to tell myself and you that we are still here. We are still Tunuka, and we need our language for our own purposes. I do this despite the colonial violence and erasure that has damaged my Métis and Tunuka families and my community. This personal reflection sets the table for my comments today. There is a fundamental distinction between settler communities and Indigenous ones, and it lies in our preoccupation with our territories, the relationship with which frames our cultures. It lies too with our experiences of land theft, coercion, and oppression, and with the denial by the Canadian state and by some First Nations bands and individuals of our identities. These matters fuel the myriad forms of sexist and racist oppression, the gifts of colonialism that afflict our lives. They are systemic as well as cultural and personal. As Raunak Wakanen wrote, gender regimes, and she could have included racism regimes, are part of institutional design. Certain of those gifts arise from the tainted Indian Act status provisions, but we remind you, the Act was always intended to eliminate Indigenous people, and it is fundamentally racist and genocidal in its institutional design. The status regime damages the fundamental human rights of Indigenous people who, but for those provisions, would be recognized within status communities and would have access to the incidence of that legal recognition from the Government of Canada. This is part of what Sheila Day calls a slow-moving, decades-long genocide, particularly focused on Indigenous women, and what the National Inquiry on Missing and Murdered Indigenous Women and Girls called a tool of forced assimilation. Note that Indigenous rights are part of the panoply of human rights that inure specifically to Indigenous people and that are both protected at international law, particularly in several sections of the United Nations Declaration on the Rights of Indigenous People, and they are at least nominally adopted by Canada. These rights allow us to be Indigenous people. There is a systemic and specific form of racialized, hypersexualized misogyny that settler state citizens and institutions project onto Indigenous women and girls, which continues to circumscribe and sometimes to obliterate the lives of Indigenous women. Canada constructed itself as a dominion inspired by the biblical Genesis, and ever since has seen itself as righteously displacing Indigenous peoples. One of the earliest impositions was the church and police enforced, state-constructed British formula for the patriarchal gendered framework prescribing the characteristics of good women and men. Mary Eberts calls this Victoria's secret for the then Queen. Indigenous women were accustomed to much more agency, autonomy, and respect than settler women, yet found themselves under the Indian Act stripped of all this and framed as the apolitical handmaids of their most proximate patriarch. That person in turn determined the status of his wife and children, just like in Genesis, and also the community to which they could belong. Marry someone from a different community or nation, and the Indian Act prescribed a transfer, regardless of the wishes of the woman or of the communities. Marry someone without status or a settler person, and women were stripped of their status, evicted from their homes, denied any share of inheritances in that community, and denied access to the meager programs available to status Indians. Their children were considered to be non-status, without Indigenous nationality or personality. They were on their own, exiled into the white supremacist racist society where they were racialized and discriminated against as Indigenous, regardless of their status. And ever since, many Indigenous women have objected, organized, litigated, and lobbied right through to the United Nations. Thank you, Sharon, McIvor, and Sandra Lovelace and your legal teams, to be recognized as who they are from their own histories and communities, and with an equal ability to convey status to their children. Indian Act racism and sexism and other racist and sexist assumptions included in Canadian culture have made Canadian society a toxic place for Indigenous women, as is manifest in the body count and testimony provided to the Missing and Murdered Indigenous Women's and Girls Inquiry. In her groundbreaking comparative study, Kuakanen found that violence against Indigenous women in Canada is more prevalent, systemic, institutionalized, and extreme than is the case for Sami and Greenlandic women. Canada has clung to the exclusionary status regimes in the Indian Act since 1876. In decisions that neutered the 1960 Bill of Rights, apologies for the male metaphor, The Supreme Court of Canada found that the Laval and Bedard cases did not manifest discrimination under the Indian Act because all Indian women were equally discriminated against, and that in Canada was equality before the law. The 1982 Charter of Rights and Freedoms, despite its enumeration of grounds of prohibited discrimination, and despite the various revisions intended to move that discrimination, has not protected us from the state's inept continuation of legislative denial of our equal rights to status, to hold it and to confer it on our children, and to the incidence of it. Despite being found in violation of its international human rights obligations in 2022, because of the Indian Act's racist and sexist provisions, that, I quote, continues to affect tens of thousands of descendants of Indigenous women today, close quote, by the United Nations Committee on the Elimination of Discrimination Against Women, the statute has never been effectively revised. Indeed, the cascade of knock-on effects of its original intentions is still perpetuated now through consequences to unknown paternity interpretations, which penalizes children whose male parentage is undocumented or unknown. This, despite the facts that colonialism has obscured many of our personal histories, and other social and gendered factors have necessitated reticence on the part of mothers in identifying male parents of their children, as Mary Eberts pointed out already. Kuakanen writes that the McIvor, Deschanel, and Gell trilogy of cases seeking elimination of sex discrimination in the Indian Act have been met with specific limited amendments to the Act rather than addressing the foundational sex-based hierarchy in the status provisions. Thus, even when Canada amends the Act, it fails to consider context and to date has not remediated its own sexist and racist legislation sufficiently. The federal government is once again contemplating amending the Act to eliminate discriminatory provisions and the odor of ordure that still arises from its status regime. Canada has produced several amendments since 1985, none of which cleansed the statute of sex discrimination, all of which continued it in some form by excluding continuing generations of Indians from legal recognition, and all of which the federal government denied or defended and perpetuated. What's up with this perpetual, ineffectual amendment process? One can be forgiven for thinking that it is instrumental. The status regime reduces the number of Indians for which the state is legislatively responsible, while simultaneously contributing to enforced assimilation, which reduces liabilities arising from colonial occupation by the erasure of those to whom the liabilities are owed. Canada has always sought to reduce its liabilities incurred through violent colonial practices and their contemporary reverberations. Think about that little human rights matter in Canada where they are supposed to be paying up for discrimination against Indigenous children. And the Indian Act, of course, was designed to eliminate Indians. Recall Kuakanen's view about institutional design. If Canada is sincere now in wishing to end its legislated sex discrimination in the Indian Act, it will cleanse the Act of any vestige of it. It will not defer to Department of Justice analyses, providing weasel words and provisions to limit the numbers of Indigenous people who may be recognized as status Indians. Canada will embrace, rather than fear, the increase in those who hold status as indicative of the resurgence of our communities, of their vitality in the face of colonialism, and as the profoundly important human resources these people represent. Canada will recognize its obligations as a result of its historical genocidal behaviors towards Indigenous peoples. Canada should also enthusiastically confer sufficient lands, which are our lands after all, and resources on banned governments so that they can properly care for and accommodate their members. And Canada should support emerging initiatives for nation formulations on our historic territories to replace the limited and limiting band structure created to contain us until we were eliminated. Canada should celebrate the return of status recognition as support for our revitalized cultures and languages and the ancient knowledges that served us so well. Canada should embrace the opportunity to take the best advice from the best informed on Indian Act revision, Indigenous women and their advocates, including people at this table, and consider cleansing the Act once and for all as one of the many necessary steps on that as yet uncharted path to reconciliation. We do not want to have to say this again. Get on with it.
Thank you, Joyce. That's exactly where we are, and a perfect place to end this. One of our participants has written in the chat box that this session has been real, raw, and informative. And I hope that's the case for everyone. It's very hard information. There is a lot of terrible harm and hurt in this story that we've been telling today. But it's very important for us to recognize the women who have been fighting for so many years, so valiantly, to end this discrimination, to articulate it, to challenge it. And we now want to talk about what we can do. So what more we can do and what people who are listening in can do. We have a couple of questions, and one of them is this. Do opportunities exist for Indigenous women to meet and speak together about Indigenous men's opposition to Indigenous women's equality? The opposition takes many forms and exists in many institutional settings, often upheld by non-Indigenous people who cannot see the gender disparities or refuse to recognize how their preferences for Indigenous default to men. Status of Women Canada used to include meeting opportunities, but they seem no longer available or are not well publicized. So I wonder if any of our panelists would like to respond to that question. Pam, can I turn to you?
I didn't work with the status of women, so I can't, I don't have any background or history. Maybe some of you who have worked with the status of women might be able to comment on it, but I have never worked with them.
And I don't think this question is specifically about status of women. I think it's about where are there opportunities for Indigenous women to talk about this kind of division and so.
I think probably that we're looking at kitchen table kinds of conversations in communities.
Yeah.
With respect to status of women, it has had its once robust roster of employees and budget whacked so that it is no longer as able as it used to be to assist. When I held the first symposium on Aboriginal feminism in 2002, Status of Women Canada was there helping me. But after that, they were decimated by federal governments seeking to balance their books on the backs of women.
Thank you, Joyce. So I'd also like to hear now from all of our panelists, whether there are particular things that you see as actions that women who are supporting Indigenous women and Indigenous women can take now in the circumstance that we're in. Pam, please start.
Yeah, so there's always things that can be done on any of these issues, whether it's human rights or land back or ending genocide. I think the most important thing to do, however, is to move away from awareness. For decades, Indigenous issues, the ultimate solution for it was public education. And don't get me wrong, public education is important. That's why I do it. But it was for the purposes of being aware. And that doesn't do anything. You need education for action. So now that you're aware and you know that it's genocide and forced assimilation and First Nations women and children are being excluded, what are the things you can do? Well, it all depends on your position. You know, if you have financial ability, you can make donations to Indigenous women's grassroots organizations and things like that. If you have, or their litigation for that matter, if you have research skills, if you're a professor, you can have students and law students working on, you know, research and arguments and citation. Like there's so much heavy lifting work that goes behind this. It's not just talking about it. You can send letters and emails to MPPs and MPs and senators and ministers, because they often respond to us, well, no one's complained to us about it. It just seems to be you and your gang. And you know, we hear that all the time, but you know, that's because there's consequences. So I think non-Native people have a duty to step up and say, imagine if we told you your kid's not allowed to be a part of your family anymore. And, you know, what does that mean? Maybe they have to be shipped off somewhere. That's just, there's just so much that people can do. There's free things too, like social media. Social media is so powerful. It's how we connect with one another. You don't need to physically be together to have a, you know, tabletop conversation like you're back home on the res drinking tea. You can just drink tea, have a Zoom conversation, and it makes it easier for people to get together. It also makes it easier to share information. So this webinar, people can share that. They can use it in their classrooms. They can, you know, make it one of their advocacy issues. Any of the unions can do that. They can help pick up the slack and do the advocating and public education. Like there's so much that people can do, even just supporting the calls of Native women when they make them and the specific calls. So it might be right now, we need money for litigation because we're in court. So that's the call in your local area for what's needed right now. Some other time it might be something else, but it's to follow their calls. And then the other part of social media is every time you like, share, comment, subscribe to a Native woman's social media, you trigger the algorithm in a good way so that all of this information gets spread out wider to where people are. You know, that's how haters online get so much attention. They trigger the algorithm by being so controversial. Well, you can trigger the algorithm for advocacy and just do that every time. And obviously, whatever your sphere of influence is, and if you're safe and able to do it, you should be exercising your sphere of influence wherever it is to advocate for Indigenous women and just simply not stop talking about genocide until they end it.
Thank you, Pam. I'm going to turn to another question. One of our participants says, why is the Canadian government so reluctant in recognizing that there is still residual and explicit discrimination in the Indian Act? In your personal opinion, do you think we should eventually abolish the Indian Act? How can we transition out of this colonial and discriminatory model? That sort of takes in everything. Anyone like to start? Mary?
I'll start with the first part of the question about the reluctance of the Canadian government. It seems, you know, from dealing with them a lot, that the Department of Justice has an approach that basically says, we will not admit that you have a right until a court has declared that. That's the deal, which is, first of all, a sign that they are loath to go out on a limb. They don't have any courage. They will not say, well, we've looked at this and we think there is a right here. No, they wait for somebody to spend 20 years and much aggravation and money to get a ruling from a court. And so I think cowardice, I have to put cowardice at the top. And the other thing is blatant financial and institutional self-interest. They have supported these gas lines. They have supported this, that, and the other thing, because resource development is a source of great wealth to Canada, and it is a source of jobs, which keeps people politically happy and so on. And they don't have any belief that giving full rights to Indigenous women or Indigenous people will have the same effect. They just want to keep the money rolling across the doorstep. And so they are temporizing all the time about recognizing full rights.
Thanks, Mary. Anybody else want to add a comment to that? Joyce, it looks like you do.
Yeah, I think we can't forget that the courts are they arbitrate the rules of the ruler. And so going to court is an uncertain proposition where we can very often find that the court is determining that Indigenous frameworks for rights and for territory and so on are not going to be recognized because they don't fit with British common law and certain precepts about state legitimacy. And I think that is why governments like us to go to court, because frankly, it's a bit of a stacked deck. And so even when we win, we lose, or even when we win, we find we can't get political implementation.
Thank you. There are a couple more very interesting questions. Here's one of them. How can Canada say they're in the business of Indian status in any other business? If any other business ran this way, it would not be viable. Imagine if it took years to process an application for a health card or a driver's license. Joyce?
The delay is the point. Remember, that act was designed to eliminate Indians. It had a process, it had intention, and it had execution. And so it's doing what it is intended to do. And if you can't get your application in until you're, 6 feet under, that's one less person.
Thanks. Pam, do you have some comment to add to that?
Well, I mean,
the
I disagree with
registration
what
system.
everyone is saying, because the delay is the whole idea for a multitude of purposes. One, people will just stop trying to apply. They'll be dissuaded, just like when Indian Affairs had a pattern of saying no for all the First Nation Inuit Health Branch applications for dental work and other medical assessments. It was their standard to say no. And even when you appealed, they said no to almost all of them. So it's just, please go away, because we save money. They unjustly enrich themselves, right? Because not only is there a delay, so you're not getting any supports, you're not getting any benefits. And then if you are finally recognized 3 years later, oh, well, yeah, we're not going to compensate you for all the discrimination, because there's a little clause that we put in the amendment saying, yeah, no, you don't get anything. So they're doing this knowingly, purposefully. They are profiting off of genocide. And remember the ultimate goal. If there are no Indians, there are no bands. If there are no bands, then they get the rest of the land. And we don't even have that much land left as First Nations, but they will get the rest of it. Then we'll have no political voice. I mean, this is their intentions. I'm not saying that's the case. We're all still going to be walking around here, but it's That's the intent. That's the whole goal. When people try to make sense of the Indian Act or compare it to what politicians are saying, like, oh, we care about our Native partners so much, just know that that's just simply not the case. It's not the case. It's not supposed to make sense. If you think about it under the, with the understanding is that they're trying to get rid of the Indian problem still, then it makes a whole lot of sense.
Thank you, Pam. Here's another, I think, very interesting question from one of our participants. She's thinking about the role of Indian bands that have their own membership codes and asks whether or not that can make a difference in the assimilation project. Can they make a difference in the assimilation project? Joyce.
Well, it's one of those things that no, because they can have their own membership codes, but they have to conform to certain parameters set by the Department of whatever they're calling Indian Affairs these days. And so this means, for example, that Tobacco Plains insists that before you can become a member of Tobacco Plains, you must have a status card. Oh, how do you get the status card? Yeah, go back to the Indian Act. So in that way, the band's own code perpetuates the Indian Act provisions. There are some bands that essentially have reanimated the old 12(1)B from the pre-1985 Indian Act and tried to claim that as Indigenous custom and therefore protect that discrimination from any legislative challenge. So I have very little confidence in bands' intent or ability because of legislative and political confinement to do anything creative with membership.
So Sheila, I'm on the other side of that. I think that in fact can be a solution and has been and is a solution in many, many, many First Nations and Native American tribes in the US. I work with these bands who have assumed control over their own membership, and it's inclusive. It's a one-parent rule. They don't include anything that's discriminatory. And then there's a whole bunch of other bands that are moving in that direction, away from, say, two-parent rules or Indian Act to a one-parent rule, because they understand finally the demographic implications of just simply perpetuating what Indian Affairs wants you to do. The other thing is some bands are more empowered with the knowledge and experience that you don't have to accept everything that Canada says. So Canada might say, oh, sorry, we're not going to provide funding for First Nation education, only for status Indians. Well, there's different ways of negotiating that in your contribution agreements. I know that's a huge issue. Bands have very little control over how much money they get and who it goes to, but that's the responsibility of Canada. So I do think once all of this is finished, all this sex discrimination and racism is finished in the Indian Act, that the transition is going to be to the bands and or the nation. So just for example, in the Mi'kmaq Nation, I'm working with Mi'kmaq bands to change their membership codes to be more inclusive, but also the Mi'kmaq Nation is working on citizenship to make sure that we don't include any of this discriminatory stuff. And so are Native American tribes. And so there's a real hope for the future. Obviously, there's 634 bands in this country, and they're all very different. So I wouldn't want to send the message that all bands are bad or exclusionary. There may be some, but there's a lot of them that are also moving towards a one-parent rule.
Thank you very much. I'm sorry to say we've now run out of time. And I can now see this conversation could go on for a long time. We've got more good questions. The participants want to thank the speakers very much. There are a lot of comments that you perhaps as the speakers have not seen, saying thank you so much for this very powerful presentation, and we want to thank you all. It's been extremely interesting, as one of our participants says, raw, real, and informative. I want to encourage everyone before we leave to stay in touch with FAFIA. We'll be providing documents on our website related to this issue, related to the new amendments that are coming up. So thank you all very much. Thank you for being here. And thank you especially to all of our brilliant speakers today.